Mr. Brummett, sir, you were picked up on a warrant for failure to register as required as a sex offender. The court finds probable cause. Bond will stay at $1,000. Further, the court is ordering as a condition of bond that you comply with all registration requirements as required by law. Thank you, sir.
Can I speak?
Sir, I'm, just to inform you, I have appointed the public defender to represent you. The public defender will advise me whether or not she wishes for you to speak at this time. Thank you, sir. I assume the fact that he's walking out, you do not wish for him to speak at this time, Ms. Eugene?
Sorry, Your Honor, no.
So, okay, thank you. Charlie Ramirez. Charlie Roberto Ramirez.
My apologies, Your Honor. We have Ms. Lee before Ramirez. Akika Lee.
Rakia Abdul Rahman. Rakia, Ms. Rahman, you are charged with providing a false name that adversely impacts another. Bond will stay setting your case at $1,000. And I do find probable cause for that charge. Thank you, Ms. Rahman.
Thank you.
Charlie Ramirez?
Yes, Your Honor. He's in a wheelchair right here.
All right, that's fine. Mr. Ramirez, in your case, you were picked up for failure to appear, 2 counts, and bond will stay at 0 bond on both counts. Thank you, Mr. Ramirez.
I got a lawyer, Miss Catherine Murray. I'm trying to find her number, so to let her know I'm over here.
Yes, you have a private?
I could appoint Catherine to help me, but she's not public defender, because the people on the case, they had a public defender
Okay,
representative.
so contact this number and they'll give you the number to contact her. So contact this number.
Okay, thank you.
Thank you, Mr. Ramirez.
Thank you, ma'am.
Agostino Rodriguez.
Good afternoon, Your Honor.
Good afternoon, Mr. Ferry. Or I think it's actually still morning,
Oh, yes.
not quite afternoon yet. Good morning.
Good, good. Matt Ferry for the record. I represent Mr. Rodriguez, who's standing to my right.
Yes, sir.
Mr. Rodriguez was arrested on a warrant, count 1, is sexual battery. I haven't had a chance to look at the affidavit in support of the warrant, but it does appear to be a first-degree felony, so he's entitled to bond. I'm requesting that the court set bond.
And let me just interject. I thought it was a second-degree sexual battery on a person greater than 18 years old by a person greater than 18 years old.
It's an
What-
F1, Your Honor.
Oh, I'm sorry. So I was considering a bond that's lower. I guess I will need to hear from the state as I miscalculated and I thought it was a second degree due to the ages. There was a witness also, so I'm going to go ahead on and swear the witness in for
Yes, Your Honor.
testimony.
This is OPD Detective Kelly Jockin. She
Let me
is
swear her
the-
in. All right. Do you swear that, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, go ahead and state your name again for the record.
Kelly Jockin with Orlando Police
Spell
Department.
your last name for me.
Ma'am, Jockin.
Okay, thank you. And do you have a title, investigator, deputy, detective?
Detective, ma'am.
All right, Detective Jockin. I assume the state will inquire of you unless the state tells me that you have something to add in a narrative, and also Mr. Ferry may have questions of you as well.
Your Honor, state has no particular questions directed to Detective Jockin.
Yes, ma'am.
She is mostly here for additional information, as she did
Yes,
hear some
ma'am.
of the additional information firsthand.
Let me just say that I do find probable cause for the sexual battery on a person greater than 18 years of age by a person under the age of 18. And for count 2, the battery, I don't need any additional information to establish probable cause based on my reading of the charging affidavit, the warrant, and the PC for the warrant. However, if there's something else that needs to be added, she may by all means do so.
Yes, Your Honor, it's not additional information as to the probable cause. It's information as to the bond and information as to some conditions that state believes may be reasonable
Yes,
in
ma'am.
this case.
That's fine. Detective Jockin, you may proceed.
Yes, Judge. Just in consideration for the bond, the Orlando Police Department did have some things to add in your consideration,
Yes, ma'am.
if I may.
You may.
The Orlando Police Department does believe that Mr. Rodriguez is a sexual predator. We are just in the early beginnings of our investigation. We've additionally, in addition to the 2 charges already arrested for, we do have 2 other prosecuting victims in this case. I do wish that that would be considered in your consideration for the bond. And as well, I do believe that the defendant could potentially be a flight risk if I may present that information to you as well.
Yes, ma'am.
When he was being arrested, the fugitive unit did hear him attempt to discreetly tell his wife if she could please turn the OnStar mechanism on their vehicle off. I believe the intention for that is to dissuade law enforcement from being able to find his location. I don't believe there's any other reason to do so. And I believe that the defendant also has access to youth and youth sports. That's definitely a consideration on our part for the public safety. Mr. Rodriguez did use his profession and trust in the community to affect all of his victims in these cases, and I do believe that he is a risk to the public safety.
Your Honor, if I may piggyback off of that?
I'm taking a couple of extra notes. I'm writing slower than she's talking, so just give me a moment. I just don't want to forget anything. I was on the part about the access to youth and youth sports, and then you were concerned because of the fact that he was engaged in his profession at the time that these allegations occurred.
Yes, ma'am, and all of the allegations, correct.
All right, so the additional investigations also involve the professional, his profession?
Directly, Judge.
All right, and Ms. Eugene, Ms. Jenkins?
Your Honor, state would just add to that I believe Detective Jockin already kind of put it on record, but the defendant is in a position of power over all the victims. He had a fiduciary duty to his patients that are the victims in this case. He does have one other open case, 22 CF 11655. It is currently the same charges that he's facing now. The bonds set in that case were $50,000 on count 1 and $500,000 on count 2. The defendant has already filed or has already posted those bonds. So state is asking for at least $50,000 on count 1 and at least $500,000 on count 2, following suit to that original case, as it is almost the same factual pattern as the case that's before the court today. And state also shares the detective's concern that he is a flight risk, given discreetly trying to tell his wife to disable the GPS on their vehicle, and that there are more victims potentially coming forward. Also by Mr. Rodriguez already posting the bond on the first case, it does show that he is at least somewhat a man of means, as that was a $50,000 bond. So state would be asking for at least the same on this case as well, taking into account that it is an F1, which is a serious charge, and that he did have a fiduciary duty to his patients. And in addition, state would ask that he surrender his passport before release to ensure that he show back up to court to handle these charges.
So let me just have Mr. Ferry to address 2 things. One, do you have any direct questions that you would like to ask the detective? 2, of course, you may address the state's request on bond as well as the request to surrender the passport.
Judge, no questions for the detective. I would like to provide the court with some information regarding my client and his background.
Yes, sir.
So address the allegations.
Go ahead.
My client is 62 years old. He has no prior record of any kind. He is a medical professional. He's a chiropractor for at least the last 4 years. He has lived in Central Florida for over 20 years. He is married for over 14 years. He has a son that's 13 years old. He's a U.S. citizen. He has no failures to appears. I haven't reviewed the current allegation, but my understanding is that these alleged victims are not any youth. They're, the prior one was a patient of his, and the allegation was that he had improperly touched the patient that was not in accordance with medical procedures. He posted bond in the amount of $50,000. I think the state indicated that count 2 was $500,000, but I think it was
500.
$500. And so I believe he has strong defenses to this particular charge. Again, he has no prior record of any kind, and I'm asking the court to set bond in the amount of $25,000 on count 1, leave count 2 the same, with conditions of no contact with the alleged victim in this case.
Do you wish to address the state's request to surrender the passport?
I'm fine with that, Your Honor.
Anything further?
No, Your Honor, just nothing that I've not already said.
All right. The defendant is entitled to bond, and as the court had reviewed the file previously and mistakenly thought this was a second degree, the court was considering a bond of $15,000. At this time, the state is asking for a $50,000 bond. Defense is asking for a $25,000 bond. The state is asking for the court to consider the defendant may possibly be a flight risk and to surrender the passport, and I'm going to grant that as defense is fine with that. The defendant is ordered to surrender his passport, and I'm going to set the bond at $25,000 for the following reasons. Florida is a state that the purpose of bond is to ensure the defendant is available and comes to court, as well as to protect the public. The defendant was in fiduciary capacity at the time that these incidents occurred, so I'm going to add an additional condition that the defendant not engage in any work. As I read, he's a chiropractor. Any work as a chiropractor that involves any patients or let me clear this up. That involves direct contact with any patients. Direct contact. The defendant can engage in work that involves indirect contact with patients, such as overseeing other staff members. That, the court feels, adequately protects the public. The court cannot presume of conditions related to youth. If there are charges related to youth, I would also order that the defendant have no contact with minor children under the age of 18. But as I understand, the victim in this case is over 18, and State, you say the other case that has actually been filed is a patient as well? And I assume that person is over 18. Please inform me if that person is under 18.
She is over 18, I believe, Your Honor.
So I believe that that case stands on its own, and it has a bond, and the defendant posted it. This case, similar in nature, adds the additional conditions of no passport or surrender the passport, all passports, just in case he has more than one. He shouldn't, but surrender all passports in your possession within 24 hours of your release to law enforcement. Possess no firearms and no weapons. Have no contact directly with any patient in your practice. And I did fashion that as a direct contact provision because I don't believe I have the ability to order the defendant to do anything that would affect his ability to continue his livelihood. So Other staff can have direct contact, however, he cannot, not with the patient. Does everybody understand my order?
Yes, Your Honor, state would just ask for also no contact with the victim. I think,
Oh, absolutely. The court orders no contact with the victim, and I think, was the victim's mother a witness in this case?
I believe so.
No contact with the victim or any member of the victim's family.
And Your Honor, in regards to the surrendering the passport, I understand that you said it within 24 hours of his release.
Yes.
They would ask that it be before his release,
Okay.
just given the
Given the
conflicts.
fact that he has an attorney who can help facilitate that, I will grant that request. Mr. Ferry, you can help facilitate the surrendering of the passport before he's released. So I'm granting the state's request and modifying the order to surrender the passport prior to release. Documentation of the surrendering of the passport must be provided to the jail before the defendant is released.
Yeah.
All right, so the clerk's office is open until what time? Okay. Mr. Ferry, the documentation will need to be provided before 4:00 PM on any day that he wishes to be released,
Okay, thank you.
because the clerk, it will be provided to the clerk's office, and it must be provided before the clerk's office. They reopen, but 4:00 PM, you said? Yes. Okay. All right. Are there any other clarifications that are necessary?
Not from the state.
Count 2, bond is set at $500. And in the event that I did not make it clear, I find probable cause for both count 1 and count 2. And as to count 2, the additional conditions are no contact, possess no weapons and no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release, and that should cover both count 1 and count 2. State, anything further?
No, Your Honor.
All right, thank you all.
Thank you, Your Honor.
Thank you, Juana.
Agustino Rodriguez, okay, that's still the same case. Mark Fitzgerald,
Bond, Your Honor.
bonded per jail staff. Ichi Kitsia,
Bond also, Your Honor.
bonded per jail staff. Mark Jason Leventhal,
Mental health, Your Honor.
Your Honor, he qualifies for pretrial.
would you like for me to address the case, or would you like for it to be reset, Ms. Eugene?
You can address the case, Your Honor.
All right, the court will order the defendant to be released on the pretrial release program. Defendant must comply with all conditions of pretrial release. No other conditions.
Your Honor, state would just ask for no contact with the victim.
On the leaving the scene, is that what's it's leaving the scene?
Yes, Your Honor.
Okay, no contact with the victim. Sometimes there are insurance issues, so I'm gonna just order no contact with the victim unless communicating regarding insurance coverage or things of that nature. Vincent D'Amelia,
Hello, Your Honor. Yes.
good day. You have 2 cases. In the first case, the court does find probable cause for cyber harassment, sexual harassment, and bond is stayed at $5,000. In the second case, the court does find probable cause for stalking, and bond is set to $2,000. The court is further ordering no contact with the victim whatsoever. State, do you wish the court to consider any additional conditions of release?
No, Your Honor, just standard, like DV conditions, the no contact and separate residences and not to return to her home.
This was cyber harassment.
The stalking, Your Honor.
So I don't think there's going to be any, the stalking was done online. So I don't think there's a no return or maintain separate residences. Do you want me to order anything specific to the use of the wide web to make contact with the victim?
Your Honor, usually, I think they were mostly emails and
Yes,
Venmo
ma'am.
transactions.
Yes, ma'am.
So it would ask for no use of Venmo.
Anything else?
Or email, Your Honor.
All right. So, sir, the no contact provision does include no direct or indirect contact, to include use of electronic devices, emails, text messaging, or social media, or any other means to contact the victim. And direct also includes not contacting the victim through a third party or under a different email or somebody else's email. You cannot contact the victim. Do you understand?
Yes, Your Honor.
I'm going to also order, even though this was not direct contact, that you maintain a distance of at least 500 feet from the victim at all times. All right, thank you.
Thank you.
Luke Delpy.
There is an offer to resolve this case, Your Honor. He did read over and sign the plea form. He'll be entering a no-contest plea for the trespass of a withhold of adjudication, credit for time served, no return to the Mentoring Motivating Youth Center at 7448 Laurel Hill Oak Circle, Orlando, Florida. And for the resisting officer without violence, it'll be a withhold, court costs, and credit for time served as well.
So this is actually a failure to appear. Were you able to establish or to stipulate to a factual basis on both counts?
Yes, Your Honor, this is actually my case.
Okay, all right, thank you, ma'am. May I see the plea form?
Yes, Your Honor.
Mr. Delpy, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or any drugs or medicine?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
And based upon stipulation of counsel, I find there's a sufficient factual basis, and I find you to be alert and intelligent as to count one. Is it a withhold on count one and count two?
Yes, Your Honor.
As to both counts, the court will withhold adjudication of guilt and order you to not return to Mentoring Motivating Youth at 7448 Laurel Hills Oak Circle in Orlando, Florida. The court further orders credit for time served. How much time served?
4 days.
4 days to run concurrent on count one and count two. And the court orders mandatory court costs, all of which must be paid within 180 days of your release. And the court does order your release as to this charge. Do you have any questions, sir?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Clarius Germain. Mr. Germain?
Your Honor.
Yes,
I
ma'am.
apologize. Client will be entering a no contest plea with the adjudication of guilt, credit for time served, court costs, and cost of prosecution. He
All
read
right.
over and signed the plea form.
Thank you. Mr. Germain, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this document in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication at this time?
No, ma'am.
Do you understand that conviction on this case will subject you to being deported if you're not a U.S. citizen? You understand that? All right, very good. Sir, there is a sufficient factual basis in your case, and you are alert. You are intelligent. At this time, the court will adjudicate you guilty. What's the time served?
2 days.
Order 2 days in jail with credit for 2 days, and order you to pay all mandatory court costs associated with this charge within 180 days of your release, and I am ordering your release as to this charge. I am appointing the public defender on this case, so court costs will include the public defender fee. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Franklin Williams. Mr. Williams.
He'll be answering a no contest plea as well, Your Honor. The offer is adjudication of guilt, credit for time served, court cost, cost of prosecution. It'll be a no contest plea. He read over the plea form and signed it.
Thank you. How much time served does Mr. Williams have?
2 days.
Right. Thank you. Mr. Williams, is this your signature here at the bottom of this plea form?
Yes,
Did you read this plea form in its entirety before you signed it?
yes,
Are you under the influence of any alcohol or drugs or medicine that would affect your thinking today?
no,
Do you understand a conviction on this case will subject you to deportation if you are not a U.S. citizen?
yes,
There is a sufficient factual basis and you are alert and intelligent, sir. At this time, you're adjudicated guilty. You're ordered to serve 2 days in jail with credit for the 2 days you have already served. Further, you must pay all mandatory court costs associated with this charge within 180 days of your release. I am ordering your release as to this charge. Do you have any questions?
no.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you.
Connor Backen,
Bond, Your Honor.
previously bonded for jail staff. Brian Larimore.
Yep.
Mr. Larimore, you have 2 cases. The first case, failing to appear, bond stays at I'm sorry, sir, that's $500. And your second case, also a failure to appear, bond stays at $500 as well on that case.
I don't get 2 failure to appears for 1 failure to appear.
Oh, maybe it is 1. Let me just look at it. This case number is 12878, and this case number is 3338. No, sir, it's 2 failure to appears.
How's that?
Your Honor, one is leaving the scene and one is Age Willis.
Yes, it's 2, sir. 2 different case numbers, sir.
That's not a, no. One court date.
Okay. Well, at this time, sir, the court is ordering the bond to remain at $500 on each case. Thank you.
That doesn't make no sense. So how am I get 2 charges for the same failure to appear?
Let's bring him back in here.
I believe that's in your division as well, Your Honor.
Yeah, so I'm just gonna give him one $500.
I believe it was a failure to appear for a comp status.
It's 2 different cases. Sir, you do have 2 different cases, but I'm gonna go ahead on and I'm going to order as follows. Case number 2022 CT 2878AO, the bond is $500. Case number 2022 MM 3338AO, and I will adjust that to release you on your recognizance. That's the leaving the scene case. But there were 2 cases. You understand? Does he understand?
What is the other case? The leaving the scene and what else?
Driving on a suspended license.
It originally,
3 months in jail for that. I did 3 months.
Well, I'm so sorry to hear that. I apologize that you had to stay in jail for so long. Thank you, sir.
What difference does that make?
Wayne Alfonso Dave Myers,
Bond, Your Honor.
previously bonded per jail staff. Spencer Osborne,
Bond also, Your Honor.
previously bonded per jail staff. Edwin Bellamy,
Refuse, Your Honor.
he has 2 cases. Would you like to waive his appearance and have me go ahead on and enter the bonds, or you want him to be reset for tomorrow?
Yes, Your Honor, you can waive.
Okay, defendant's appearance is waived. As to the first failure to appear, bond stays at no bond, and as to the second failure to appear, bond stays at no bond. Scott Keenan Bell.
Ma'am.
Sir, you're picked up for possession of 3,4 methamphetamine MDMA ecstasy, for which bond stays at $1,000. Further, the court will take no action on your out on bond matter. Thank you, sir. Thank you, sir. Kayvon Decine Buckland. Mr. Buckland, as to your charge of fleeing and attempting to elude a police officer, the court finds probable cause, and bond is set at $4,000.
Your Honor,
Yes,
for that one, state would ask for the condition of no contact with documented gang members.
no contact with documented gang members?
Yes, Your Honor.
Okay. Further, the court is going to order a condition that you have no contact with documented gang members. As to case number 2022 CF 1484 BO, for the failure to appear on your robbery charge, bond will stay at no bond. As to case number 2022 CF 9652 for the new law violation of possession of a counterfeit payment instrument, bond stays at $5,000. And grand theft in the 3rd degree, bond stays also at $5,000.
Your Honor, on this one, state did file an information with an additional charge of uttering forged checks.
So the court will set bond at ROR on that count.
And state would ask for the same condition of no contact with documented gang members, Your Honor.
That's granted. The court is ordering as a condition of bond, no contact with any documented gang members, and no contact with the victim. As to case number 2022 CF 395 BO, bond stays at no bond on both count 1 and count 2 for failure to appear on each count. Thank you, sir. Jessica Camarillo.
Yes, ma'am.
Ma'am, in your case, the court finds probable cause for felony battery, and bond will stay at $5,000. Further, the court is ordering no contact with the victim, possess no weapons or firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release, and no return to the scene.
Okay.
Thank you. Ricardo Shang. Mr. Shang, in your case, the court finds probable cause as follows. Count 1, possession of methamphetamine with intent. Bond will stay at $15,000. Count 2, possession of cannabis less than 20 grams. Bond stays at $100. Count 3, possession of drug paraphernalia. Bond stays at $100. And count 4, resisting an officer without violence. Bond stays at $100. As to your out on bond case, the court revokes the bond and orders a new bond as follows as to count one.
Your Honor, that originally came in as a possession of meth with intent,
Yes,
which
ma'am.
is the exact same charge. And that,
My intention was to double the bond to $32,000.
okay, Your Honor.
Bond is set to $32,000 on count one, no action on count two, no action on count three.
You have bond on it.
Just to clarify, Madam Clerk, bond on count one is $32,000. My addition may be wrong, but that's the bond. 32,000, okay? Thank you.
If you have collateral.
De Almeidas Cifuentes. Mr. Cifuentes, in your case, you were picked up on a capias for, was this failure to appear?
I believe the state of Florida filed a motion to revoke his release. That's what I've read.
Actually, I think I need more information on this. I assumed it was a failure to appear. It came in at, judge ordered failure to appear. Sorry, judge ordered bond set at zero.
I see a KPS on September 6th.
It does say capias, but it doesn't say the reason why.
It was dismissed.
Usually I have a reason why the capias is issued, such as failure to appear. Madam Clerk, can you help me out with, let's see here, the date on, was there a capias issued prior to August the 23rd? On or prior to August 23rd, 2022?
Your Honor, what I'm seeing, looking at the clerk site, is there was an order setting pretrial in June,
Yes, ma'am.
and then in August, there was a motion to revoke pretrial release. There was an order revoking release, and then a KPS issued.
What was the reason for the motion or the order? Does the order indicate the reason?
There was a motion to revoke pretrial release. While on bond or pretrial release, the defendant committed a new crime, battering, dating violence, in 22 MM 5276. So state filed a motion to revoke pretrial release,
Okay.
picking up a new law.
So did he have an initial appearance and they just did not address it at the initial appearance on the new law? Or has he never had his initial appearance on the new law yet?
Double check. 22.
And I'm gonna follow the judge's orders. She did sign an order on the 18th of August, 2022. However, because of the fact that you've given me the reason why, being the new law, then I want to be sure the new law actually was filed. If it wasn't, then maybe we need to contact the judge and see if the judge still wants this order.
So,
What exactly do you want?
on the 5276, it was IA'd in May.
Yes, ma'am.
There was a no contact order, bond filed, and then it was no infoed.
When was it no infoed?
June 8th of 2022. However, when I pull that
Okay.
case number on the clerk site, it comes to Judy Petty-Freary. I don't know if that is a AKA.
Can you give me the date of the no info again?
6/8 of 22.
6/8 of 22. And Madam Clerk, you say there's a private attorney? Who is it? Roger Weeding.
The one mentioned within the
The battery charge.
state's order or state's motion.
Yes, ma'am.
Oh, sorry, I just lost it. State's motion, the 22 MM 5276 AO.
What do you mean by a branch case? In case it's Ocoya, Poplar, or Winter Park? Okay, so the concern the court has is just as to if the case actually was no infoed, perhaps Judge Wilson would no longer want the defendant to be held on no bond. He's not represented by the public defender on the misdemeanor. Ms. Eugene, I've been informed by, he actually is being represented by Mr. Whedon.
Your Honor, the order revoking was after the no info in the other case.
It was after the no info,
The no
but
info
that,
was June,
yes.
the order revoking was
yes.
August.
But if it was revoked because of that case,
I don't know.
are we sure the judge had all that information? And let me just tell you, I'm not gonna do anything, to Judge Wilson's order because I don't know what information Judge Wilson had. What I'm suggesting is we just make sure that she, we didn't either change this order or, had all that information, but since Mr. Whedon is not involved in this hearing, I can't take any action on it anyway, because he needs to be involved in this. And, okay, go ahead. That's what I wrote, 5276. Is it AO? No, it's 20. I wrote 2022 MM, 5276 AO. So that's what I had. Is it Mr. Whedon as counsel or the public defender? Okay, so you can handle this, Ms. Eugene. The other case, I guess, when she put in a different case number, she saw a different lawyer. So the public defender is actually attorney of record. And so I had, my original suggestion was going to be that we reset it for tomorrow and give the attorneys an opportunity to look at it, and let's confirm that this is the actual case that Judge Wilson made her decision based on. And if it is, whether or not Judge Wilson would like to have him released, because the case was no info. And if it's not, then what is the case that caused Judge Wilson to make her decision?
So, Your Honor, we were setting it for tomorrow for more time to get in contact to see what Judge Wilson would like to do in regards to this case?
Well, I think I'm resetting it to give the parties, the state and the defense, more time to confirm the reasons why the bond was revoked. So we all know that the state filed the motion. Since the state filed the motion, if the state filed their motion based on a case that the state has now no information, then the state may also file a motion asking the court to set a bond or to release the defendant ROR. Or alternatively, the parties can consult with Judge Wilson and find out what information Judge Wilson based her ruling on. But the state initiated this, so the state can stop it. It's up to the state how you all want to handle that. Does that clarify my answer? Does it clarify to you what I think you all should do?
Yes, Your Honor. Client would just like to resolve it today. I don't mind resolving it today either, if the state has no issue.
It's a felony, that's not an option.
And let me just say that we're not resolving
I mean,
this
sorry, as in
case.
like setting like RR or like a bond amount.
I'm not setting an ROR, and I'm not setting a bond amount because I have no idea why Judge Wilson ordered no bond. I just believe that based on everything we see, that she ordered it based on a case that the state has dropped.
Okay, understood.
But I could be wrong about that. There may be a different reason. And I'm not so sure that Judge Wilson needs to be involved in this at all. I just believe that that's one alternative is to get Judge Wilson involved. But the other alternative is, since the state is the one that initiated it, and if the state initiated this based on a case that the state no longer believes the state wants to go forward on, then the state can also file a motion and request the judge to ROR the defendant or set a bond for the defendant. It's up to the state how they want to proceed. So do you all think you can do this in 24 hours, or you want me to set it for Monday instead?
I'm currently emailing the ASA in that division who filed that motion to try to figure out what and why.
So 24 hours is
I
sufficient?
believe it'll be sufficient.
All right. All right, so what to tell the clerk to write?
Just
Okay.
reset till tomorrow for additional information.
Okay, from the state, additional information from the state. Okay? Not from the judge, from the state. We don't have to involve the judge unless the state doesn't want to do anything. All right? Got it, state?
Yes, Your Honor.
Okay. Ms. Eugene, you got it?
Yes, Your Honor, understood.
Additional information from the state. But in the meantime, bond will stay at no bond. Thank you all. That was convoluted. Anthony Coleman. In your case, the court finds probable cause for possession of methamphetamine and bond stays at 1,000, and possession of cocaine. Bond is set to 150. Thank you, sir. Harneil Coney. In your case, the court finds probable cause for aggravated assault with the weapon, without a deadly weapon, with a deadly weapon. Count 1, and bond is set to $10,000. Count 2, aggravated assault with a deadly weapon. Bond is set to $4,000. Count 3, aggravated assault with a deadly weapon. Bond is set to $4,000. As to these counts, the court did increase the bond based on the increased danger to the public. This was done in a motor vehicle, which could impact not only the intended victims, 3 victims in the cars, but others who were in the parking lot and who were in the roadways adjacent to the parking lot as well. So this is a little bit of a higher bond on count 1. Further, the court is ordering that you possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release, and that you have no contact with the victims. The court is ordering that you not return to, I don't remember, what was the store where this happened?
Multiple different places, however, I think they ultimately ended up in a Tijuana Flats and.
Yeah, it was a shopping,
Chase Bank.
a shopping mall. No return to the shopping mall where this incident occurred. No return to the Tijuana Flats or the Miller's Ale House or any of the businesses that are adjacent to where the parking lot is where this occurred. Cody Ray DeSantis.
Bond, Your Honor.
Thank you. Bonded per jail staff. Joshua Granger.
Yes, ma'am.
In your case, the court finds probable cause for trafficking in methamphetamines greater than 14 grams and less than 28 grams. Bond stays at $50,000, and possession of cannabis with the intent to distribute, and bond stays at $150.
Your Honor, in regards to this, is it possible if we get a more reasonable bond in regards to count 1?
Is there a reason, a basis for requesting it?
Yes, Your Honor. Based on his income, he's unable to afford the $50,000. 1 second, please. 1 minute, please.
What says the state?
Your Honor, he has at least 3 prior failures to appear. His last conviction was a selling of cocaine and possession of firearm by a convicted felon. And he has an extremely lengthy criminal history, including being a multi-source offender from many other states. I believe he's also a supervised offender on U.S. probation out of the Middle District.
He is currently on probation at this time?
It appears so based off the pretrial. He's on federal probation.
Okay. Pretrial, can you confirm that?
Yes, it shows that.
The court will decline to reduce the bond at this time.
1 second, 1 minute, Your Honor, can I?
Yes, ma'am, you can have a moment.
I believe he also has an open case out of Georgia.
Okay, thank you. The basis, just so the public defender is aware, is that the defendant does have a prior criminal history and the defendant is currently being supervised.
Okay. Your Honor, I do apologize, but client is just saying that he's not being supervised. He was released from that supervision in April.
April of this year, 2022?
Yes.
All right, so can we confirm that?
I'm waiting for the website.
Depends what you want to say.
And state, does he have any, to your knowledge, any open and pending cases other than the case that I just ruled on?
She's gonna look at that. And if I can add, Your Honor, client does have 4 kids, and he's the primary caregiver in regards to providing for them financially as well.
All right, thank you for that additional information.
I don't see anything else currently open at this time. However, 50,000 is the bond schedule, which I understand Your Honor can deviate from. It is just a guidance.
I think that the main concern the court has is he currently being supervised or not? I want to just have accurate data on that. If he is currently being supervised, I won't even consider reducing this bond. But I want to have accurate data. If he's not currently being supervised, I want to at least listen and then make a determination. But I don't want to make a determination based on inaccurate data.
According to the hot file, it's showing that the start of the supervision was July the 26th,
Yes, ma'am.
2019.
Okay.
It has a date of the expiration date for the probation as non-exempt, but then it shows the date of release from supervision as July 25th, 2020.
July 25th, 2020.
Yes.
So he may actually not be under supervision at this time on that case?
May not, but it's still showing the non-expired, so there's no clear
It's unclear.
documents on
Okay.
it.
What does it show us the expiration date?
It's showing
What year?
2020.
2020. Okay.
But then,
Sir, a reduction in the bond is certainly something that I want to consider. However, if you're currently being supervised, I would deny it. I would deny it flat out. And there's a chance you are still being supervised, then I'm just going to have to ask your counsel to contact, it's a federal supervision,
Yes, ma'am. It was,
to contact the department that's responsible for supervising you and confirming whether or not supervision has been completed, in which case then I would consider reducing the bond. But without that information, I am not going to reduce the bond at this time.
understandable. I had got released from Orange County back in April. I had got sentenced to 8 months. U.S. Marshals to the BOP. Judge Roy B. Dalton Jr. had terminated my 8 months. Well, he sentenced me to 8 months and terminated all probation to follow. I was released from Orange County back in April, and if I was still on probation, I mean, the lady downstairs from pretrial told me about probation, but I don't see how I got released, the judge terminated, and I haven't checked in with any officers since I've been home.
Well,
I have a job, man.
Your Honor, his out on bond is also another drug offense.
Ms. Fleming, what did you say?
I said his out on, or his other open case currently that's from Georgia is also another drug offense.
The motion is denied. Denied at this time. At this time, it's denied. The defendant may have leave to file a motion if additional information comes available.
Your Honor, if we may, can we ask if we can roll this for 24 hours to see if we can have enough time to see whether or not he is on federal probation?
Based on the additional information from the Georgia case, I would deny it, so let's deny it.
Okay. Yes.
Sean Greenlee? Are you Mr. Greenlee? Yes, ma'am. Mr. Greenlee, in your case, the court finds probable cause for possession of cannabis greater than 20 grams with a weapon,
Not right now.
and bond will stay set at $15,000. Possession of cannabis greater than 20 grams, bond stays at $1,000. Fleeing, attempting to elude a police officer, the court sets a bond of $150. The court revokes the bond on case number 2021 CT 143 AE, and sets a bond of no bond.
Your Honor, in regards to that, we're asking the court to not revoke bond on that case because he does have a private attorney assigned to that case. And he's currently actively fighting that DUI, Your Honor.
Oh, what says the state? Do
Your
you-
Honor, state would object. He was driving a vehicle and fleeing and attempting to elude an officer with drugs in the car, which is,
I tell you what I'll do, I think she's right, he does have a private attorney. I'm not doing it because of the private attorney per se, but I just out of knowledge, I happen to know that this attorney has been sick and otherwise might have been here today.
it is set for a motion to suppress currently.
No. All I'm saying is I'm not gonna do it because I know that the attorney has been sick because of cases that were set in my division, and the attorney was unable to attend. Other attorneys did come to most of his hearings on his behalf, but perhaps no one realized that his client would be here today. So because of that, I'll grant that request. It's not because of it being a private attorney, it's because the attorney may, regardless of private or public defender, may not have been aware of this hearing today and would have wanted to be present.
Your Honor, just for the record, state would object. He is obviously a danger to the community. he's out on bond for a DUI and he's fleeing and attempting a law enforcement officer with drugs.
Well, she's asking me to reset it. Aren't you asking me to reset
No,
it?
she's
No,
asking
I can
for
take no action, no action in regards to DUI, but if you would like to reset it for 24 hours, that'll be fine as well, Your Honor. No.
You all are, so the third count is fleeing and attempting to elude an officer, which means that you were driving. And then, why don't we just call the attorney's office and see if they want to be present? He has other attorneys that work in that office other than him. We'll see if they want to be present at the hearing, that he is represented by counsel. So we'll just do that, and then I'll decide after the attorneys who actually represent him are able to give their input. So we're gonna call the attorney's office. I can have Juanita give you the number real quick if you want.
I have it.
Okay.
407-246-0066.
And you could ask according to this, it's Mr. Barlow, but or any attorney with the office who may not be aware that he had a hearing today. And if they want, we can set it for tomorrow for 24 hours if they prefer to be present.
And Your Honor, just for the record, it is a drug DUI.
Oh, it's a drug?
Yep.
Okay, thank you. Okay, thank you. I'm going to pass the defendant's case, Mr. Greenlee's case, for approximately 5 minutes. So we can just, we'll recall him shortly. Michael Greider. In your case, the court finds probable cause for count 1 through count 6. As to count 1, possession of cannabis, bond is set at stayed at $150. Count 2, possession of fentanyl, bond is stayed at $150. Count 3, possession of a controlled substance, bond is stayed at $150. Count 4, possession of cannabis with intent to sell or deliver, bond is stayed at $150. Count 5, possession or discharging of a destructive device, bond is stayed at $5,000. Count 6, making or placing a destructive device, and bond is stayed at $150.
Your Honor, in regards to this case, defense counsel did have a PC challenge. I feel as though the affidavit was too short and we needed a warrant in regards to, and more information in regards to this case.
So the affidavit was extraordinarily short. It was a very short affidavit. She's right about that. But the court simply needs to find probable cause. The court doesn't have to look at the length of the affidavit or whether it's short or whether it's long. This is an affidavit that has probable cause, and I find probable cause. I am also ordering possession of weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release.
Your Honor, is it possible if we can get the $5,000 bond lowered to a reasonable amount?
What says the state as to the $5,000 bond on count 5, possession of a destructive possession of or discharging of a destructive device.
Your Honor, state thinks it's reasonable, given that all the others are already treated as subsidiaries, so it would have to stay the same.
The court is going to deny that request at this time. Let me just, before I deny that, this, it says that, she's right about this being short. You can't be more right about that. But I do find probable cause. The last sentence is, state, can you read that last sentence?
He said he dismantled the ammunition this way to keep it safe.
What is that word? Reminisce of shotgun ammunition? What is that? What are they talking about?
I believe, I mean, as Your Honor, I'm reading the same thing you are. I believe he was taking apart ammunition. So I believe reminisce means it looked like shotgun ammunition that he had found. He dismantled it to try to keep it safe. So it was taking it apart. If Your Honor's uncomfortable with 5,000 on 5,
Yes, I'm gonna reduce that.
5,000 is reasonable on 4 or any of the other charges.
It's definitely reasonable on 4. So, listen, I am a little uncomfortable with 5,000 on count 5. So I'm gonna, Madam Clerk, set a bond of $150 on count 5. However, I'm going to set a bond of 5,000 on count 4. Thank you all. Wilma Alberto Gutierrez Penuela, previously bonded per jail staff. Ishmael Khalid Harrison.
Present.
The court finds probable cause for carrying a concealed firearm, and bond is stayed at $2,500. The court is ordering that you possess no firearms or weapons as a consideration of bond, and that you surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you. Isaiah Hill.
Mental health, Your Honor.
Ms. Eugene, in his case, the court was able to find probable cause. If you wish to waive, I'll address it at this time, or do you wish for me to reset?
We can waive, Your Honor.
All right, the court finds probable cause, bond stays at $2,500. The defendant is ordered to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release, no return, and no contact. No action on the defendant's out on bond case. Terrence Holloman. Sir, in your case, the court finds probable cause for possession of a controlled substance and bond stays at $1,000. Laura Jackson. Ms. Jackson? Ma'am, the court finds probable cause in your case for possession of drugs without a prescription. And bond is stayed at $1,500, as well as possession of paraphernalia for which the court will set a bond of $150. You're ordered to consume or possess no unlawful substances or drugs or narcotics without a prescription. Andrew Jagwandan,
Bonded, Your Honor.
previously bonded. Also in this case, Ms. Public Defender, I am not appointing the public defender due to income.
Okay, thank you.
Rico Johnson,
Bonded.
previously bonded per jail staff. David Keister,
Mental health, Your Honor.
would you like for me to address this case today? I am going to revoke the bond on the out on bond case.
Yes, Your Honor, understood. We can waive.
All right, and the court finds probable cause on count 1 and count 2. Bond stays at $2,500 on count 1 and $150 on count 2. The court revokes the bond on the out on bond case and sets a new bond of $5,000. Lincoln King. Sir, the court
He's
finds,
here,
sorry.
He qualifies for pretrial.
Thank you, ma'am. The court finds probable cause in your case for grand theft, and I am ordering you to be released on the pretrial release program. You must comply with all conditions of pretrial release. You must also have no contact with the victim. Thank you. Woodson Logist. Sir, in your case, the court finds probable cause for count 1 through count 4. As to count 1, fleeing and attempting to elude a law enforcement officer, bond is set to $4,000. Count 2, possession of a firearm in the commission of a felony, bond is set to $150. Count 3, possession of a cannabis with intent to sell or deliver with a weapon, bond is stayed at $15,000. And count 4, possession of cannabis greater than 20 grams with a weapon, bond is set to $150. You're ordered to surrender all weapons or firearms to law enforcement within 24 hours of release and possess no firearms or weapons. Christopher Lynn. Mr. Lynn, the court finds probable cause for dealing in stolen property, and bond is stayed at $2,000, violation of the Florida Pawnbroker Act. Bond is set to bond is stayed at $1,000. Burglary of a structure, bond is stayed at $5,000. Grand theft, third degree, bond is stayed at $1,000. You are further ordered to have no contact with the victim and no return.
Your Honor, can I speak to client for 1 minute, please?
You may.
Your Honor, is it possible we could reduce, if his bond can get a reduction to equal a total amount of $4,000 based on his income and what client has told me that's the maximum he could afford?
Can I see his file back? And is this Mr. Christopher Lynn?
Yes, Your Honor.
So, Mr. Lynn, in your case, the court actually would have, I would grant that, state if you have no objection.
Your Honor, state would just bring it to your attention, he does have 10 prior failures to appear. His last conviction was a burglary, which is also a charge that he's here for today. And he's also currently out on bond for another Orange County case, possession of a controlled substance and loitering and prowling.
So, yes. Is he involved in any violent felonies?
He has prior convictions for violent felonies. He doesn't have a current open violent felony.
Okay. I want to grant that request. As to count 1, the court will set a bond of $2,000. As to count 2, the bond is set to $150. As to count, let me change that, I'm sorry. As to count 1, bond is set to $150. As to count 2, bond is set to $150. As to count 3, bond is set to $2,500. As to count 4, bond is set to $150. The court is ordering no contact with the victim and no return.
Can't do math, though. Just add it all together. Let's do no bond.
Angel Luis Melendez,
That's for 10% class.
this case will be reset for 24 hours. Defendant refused. Joshua Mendez,
Medical, Your Honor.
medical, do you want to waive?
Yes, Your Honor.
As to this case, the court finds probable cause for attempted burglary of a conveyance. Bond is stated at $1,000. The defendant is ordered to have no contact with the victim and no return. Alexis Odom. Sorry?
Crystal Alexis Odom.
Are you saying that you are Alexis Odom?
I'm saying my name is Crystal Alexis Odom.
Oh, okay, but you are Alexis, so I just want to be sure I have the right person.
Yes, ma'am.
Now, in your case, the court does find probable cause with tampering with physical evidence, bond is stated $1,000. Possession of cannabis less than 20 grams, bond is stated $250. Resisting an officer, the court does set a bond of $150. You also have an out of county, in St. Lucie, bond is stated no bond, and an out of county in Volusia, bond is stated no bond, and I am appointing the public defender, even though it indicates an income of $1,800 every week, every other week, because of the no bond status on the 2 other cases where she is not going to be able to bond out. So I'm appointing the public defender. Christopher Isaiah Ortiz,
He bonded.
previously bonded per jail staff. John Peters,
Bond, Your Honor.
previously bonded per jail staff. Joshua Pieper,
Refuse, Your Honor.
I'll reset for 24 hours, defendant refused.
We're not leaving?
Oscar Alejandro Porto Rivera.
Yes, ma'am.
Sir, you have 2 cases. On your first case, the court finds probable cause. You actually have 3 cases, I think. Let me just look back at my notes. I find probable cause for the grand theft motor vehicle, and bond is stated at $1,000. Your second case, driving on a suspended license with knowledge, and the court does order a bond of $500. So you only have 2 cases, like I said before, I just miswrote something. You are ordered to not drive without a valid driver's license, have no contact with the victim, and no return. Madam Clerk, let's readdress the Sean Greenlee matter. All right, recalling Sean Eric Greenlee. Mr. Greenlee, this is him. Mr. Greenlee, I'm resetting your case for tomorrow, 24 hours, to give your retained counsel an opportunity to be present. However, the order on the new case remains. Madam Clerk, $15,000 on count 1, $1,000 on count 2, $150 on count 3. It's being reset on the revocation, the issue of revocation of the bond on the driving under the influence.
Your Honor, in regards to count 1, is it possible if we can address that being reduced at this time? Or do you want to address that?
The nature of the charges involves a weapon, and the court will not consider that at this time.
Okay.
But for your notes and for the state's notes, please make a note. The court has set a bond on the new law violation. The case is simply being reset to address revoking the bond, understanding that the attorney who represents him on the older case the court was aware that that attorney may not have been able to be present. So that gives them an opportunity to either have him present or send someone else.
Will client be able to bond out, or just no action is taken on a DUI, Your Honor?
That's a good question. Well, what says the state?
Your Honor, state would ask you leave count 3 at no bond currently, so we'll have to be seen tomorrow.
Or do you want me to just go ahead and revoke the bond and just reset it for a rehearing on the revocation of the bond?
That works as well, Your Honor.
Okay, then that's what I'll do. The court is ordering revoking the bond on 2021 CT 143AE and setting no bond. However, this is the matter that the court will allow to be reheard on tomorrow. The court is not anticipating that the issue of the bond that I ordered on the new case be reheard. However, I have no objection if the judge wants to rehear that.
Can I get 1 minute, Your Honor, to explain that to client?
Absolutely.
Thank you.
Yes, ma'am. I hope I'm not confusing tomorrow's judge. Okay. 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 And essentially, it's being reset so that the attorney who represents him on the old case can be heard. That's the only reason it's being reset.
For now. So they're gonna address it tomorrow.
All right, thank you, Ms. Eugene. I see him leaving, so you're ready?
Yes, Your Honor.
Travis Randerson. All right, you have 3 cases as to, the first case, burglary of a structure while wearing a mask and petty theft.
Your Honor, state did file on information. We ended up filing a burglary structure, which is an F3 instead of an F2,
Okay,
and a petty theft over 100, which is an M1. So state just asked, we take that into account when setting his bond.
okay. The petty theft is an M1, right?
Yes, Your Honor.
Okay, all right, so as to the burglary of a structure, the court will stay the bond at $2,500. As to petty theft, the court will set a bond of $150. For your failure to appear, bond is stayed at $250. For your third case, grand theft involving a firearm, state, did you make any changes to that?
Your Honor, state did file information on this one as well. We did file the grand theft of a firearm. However, as to count 2, we filed a burg structure, which is an F3 instead of that F.
Armed burglary, okay. So as to count 1, bond will remain and stay at $10,000. As to count 2, the court sets a bond of $150.
Your Honor, state would ask for no contact, no return on all cases.
Granted, the court is ordering that you have no contact with the victims on all cases and that you not return on all cases. I am also going to order that you possess no weapons or firearms and surrender any weapons or firearms in your possession to allow enforcement within 24 hours of your release. Thank
Your Honor,
you.
I apologize. Can I get not 1 minute, but client would like the $10,000 bond lowered if possible to something reasonable?
The court has already considered whether I would lower the bonds in these cases when I reviewed the cases. Now, I will say I did think that count 2 was armed burglary, but however, the state has charged that as a lesser offense. So what says the state as to a reduction of the count 1 in the third case of grand theft, 3rd degree with a firearm?
Your Honor, state would ask that it stay there. Mr. Randerson currently has 3 open cases. He at least has 1 prior failure to appear, several prior VOP showing inability to comply with court orders. And even though state did downfile the armed burglary, Mr. Randerson did still possess a firearm, hence the grand theft of a firearm charge.
Right.
So state would ask that it stay as it currently is.
Okay. Does he have any pending violent or convictions for violent offenses?
Let me double check. I know his last thing was an accessory case. I don't know what, I'm checking to see what it's an accessory for.
Accessory after the fact of burglary.
Your Honor, I don't necessarily see violent offenses. They're all theft offenses. He has a 2021 trespass of occupied structure, paraphernalia. The 2018 felony accessory de facto burglary, accessory de facto grand theft, fraudulent use of a credit card. And then he also has burglary and trespass charges as a juvenile, petty theft charges.
It's my understanding that the grand theft of a firearm is an F3.
Yes, I believe so.
I'm going to grant the defense motion, and I'll reduce the bond to $5,000. As to count one only. Madam Clerk, that's case number 2021 CF 2021 CF 6922AO. All other cases, the bonds remain as previously ordered. Thank you, sir. Malachi Rogers. Sir, you have 3 cases. The court orders as follows: grand theft of a motor vehicle with a mask, bond stays at $2,500. That's your first case. Possession of cannabis less than 20 grams, bond stays at $500. Burglary of a conveyance while wearing a mask, bond stays at $5,000. Count 2, petty theft, bond stays at $100. And count 3, criminal mischief, bond stays at $100. The court is taking no action on your out on bond matter. Thank you, sir.
Your Honor, can I just get 30 seconds to speak to client for 1 minute?
Yes, ma'am.
30 seconds, sorry.
And Your Honor, State would ask for no contact, no return, please.
Yes, ma'am, I will include both. Ms. Eugene, I am also ordering as to all cases, the defendant have no contact with the victims and no return. Thank you. I see he's now leaving.
Your Honor.
Anthony Scott. Mr. Scott, sir, in your case, count 1.
Your Honor, it appears we have a witness or a victim.
Oh, yes, ma'am. Ma'am, please raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please state your name into the microphone and make sure you answer all questions asked of you into the microphone.
Ingrid Solomon Scott.
Ingrid Solomon
Scott.
Scott. All right, Ms. Scott. Go ahead, Ms. Fleming.
Your Honor, State has no questions. She's not an alleged victim or witness.
Okay, Ms. Eugene.
No questions at this moment, Your Honor.
All right, Ms. Scott, neither the state nor the defense is asking you any questions. Is there some reason why you wanted to come today to say something to the court?
Well, I wanted to speak on behalf of my husband.
Go ahead.
I just wanted to make note that he's a retired New York City.
And you're gonna need to speak into that microphone, ma'am.
He's a retired New York City correction captain, and he went out to do an oil change on my behalf as his wife.
Yes, ma'am.
And then the altercation happened.
Yes, ma'am.
That's what I wanted to say.
Is that all you wanted to say?
Yes, he's been married for over 40 years.
So, ma'am, you're breaking up now. I need you to stay at that
We've been
microphone.
married for going on 40 years. Our oldest son is here with us.
Okay.
Retired employee in the state of Florida. We now reside.
Anything else you want to tell me?
No, that's it for now.
So are you here today to support him?
I'm here to support him. Also, just to make sure that he's able to get bond, because we didn't see any bond last night. when we came.
I am ordering a bond, ma'am, as follows. I do find probable cause for the aggravated assault with a weapon without intention to kill. And the court is setting a bond, or staying the bond is actually, I'm not setting a different bond. The bond that was set, I'm staying it at $2,500, so that's the bond on count 1. Count 2, drug possession or drug equipment possession. Bond is staying at $100.
Your Honor, in regards to this case, if I may,
Yes, ma'am.
if client qualifies for RRR, depending on the severity of the offense, client does not have a criminal history. We're asking if we take that into consideration if we want to, if the court would like to RRR client in regards to the cases.
Your Honor, state would object. It's a violent offense. He does not qualify for ROR.
Well, based upon the, count 1 is an aggravated assault involving a weapon. Although it's without intent to kill, it's still, the court does consider it to be a violent offense. And the court is at this time not amenable to an ROR on count 1. However, I will ROR the defendant on count 2, which is drug possession or paraphernalia possession, which is not a violent offense, and he doesn't have any priors according to the defense state. You haven't countered that, so I assume that's correct. Now, the court is ordering possess no weapons or firearms as a condition of bond, and surrender any weapons or firearms to law enforcement within 24 hours of release, and have no contact with the victims. Anything further, ma'am? Thank you, ma'am.
Your Honor.
Yes, who's saying, Your Honor?
Pretrial.
Okay, yes,
There
Ms.
was a
Keys.
bond correction form. It was changed to 0, the amount. So do you want the amount to be the 2,500?
Yes,
Okay.
I want the amount to be the 2,500. So what happens with these bond corrections is the officer, he had put in 2,500, then he realized he could actually do no bond, but the judge is
It was a no.
obligated to set a bond at IAs. So we're at IAs now, so I'm setting a bond at the initial appearance of $2,500. Thank you all. Martino Sorial. Sir, in your case, you were picked up for failure to appear. Bond will stay at no bond. Thank you, sir. William Sparks.
Refuse, Your Honor.
Mr. Sparks' case will be reset for 24 hours. He refused to come to court. James Thorne.
Yes, Your Honor.
In your case, the court does find probable cause for the charge of lewd or lascivious molestation on a victim less than 12 years of age. The court is ordering bond of no bond, ordering no contact with the victim or witnesses or any minors under the age of 18.
Is my lawyer here?
Oh, I'm sorry, sir. Did you have a lawyer? What's your lawyer's? You know your lawyer's name?
Yes, Michael LaFay, and I was.
Hold on a minute, sir. I don't have any indication that Mr. LaFay was planning to be here. Can we confirm that Mr. LaFay has filed a notice of appearance?
I don't see one.
You don't have anything? Okay. At this time, we don't have any indication that Mr. LaFay has filed a notice of appearance on your case, so I could call his office and see,
Yes, please.
or I could reset it for in the morning.
Could you call now?
Well, why don't we do that? Let's just call Mr. LaFay and see if he plans on representing this gentleman.
The reason I'm saying that is outside, they said they did call when I said I was denying access to phone to
talk to him.
It's not, sir, we're gonna call Mr. LaFay's office. Now, I don't know if Mr. LaFay is in the office. I have no idea whether we're gonna get Mr. LaFay. But because we could easily have him appear virtually if he is available, I will give his office a call since you say he's representing you.
Yes.
But I don't know what we're going to find out, so. Hold
So
on
you
a
have
second.
Nee James.
Yes, that's, it's the Nee James firm. Anyone have it, or do I need to look it up on the Florida bar?
I have his phone number.
Well, we'll get it one way or the other.
For the Nee James main office number, 407-500-0000.
Okay. So we're going to call his office right now, and we don't know whether we will make connectivity with him. If I am unable to make connectivity with him, you are appointed to be represented by the public defender, and I'm going to lead the public defender on your case unless and until Mr. LaFay actually files a notice of appearance.
I have another phone number as well, if that one doesn't work.
They can appear virtually if they wish to do so, if he is representing this gentleman. They will not. The confirmation that we have received is that Mr. LaFay's office is not representing you at this time. And so therefore, the public defender has been appointed and is representing you, and bond will stay set at no bond, along with the conditions of no contact with the victim or witnesses or any minors under the age of 18. This does not mean that you cannot continue your communications with Mr. LaFay's office and retain his office to represent you. But in the meantime, before his office actually becomes affiliated with your representation, you do have an attorney to represent you, and that is the public defender's office. Thank you, sir.
One other thing, can I get a reconsideration on a no bond, as this is my first offense, and also I have a full-time job, and I would basically follow all restrictions of the court with the no contact or anything else like that. And this way I can take care of my affairs, plus make sure I get my dog taken care of and things of that nature.
What says the state?
Your Honor, state would object. It is a first-degree felony that's punishable by life. And the age of the victim was allegedly 4 years old, so state would object at this time, pending an Arthur hearing at a later time.
The nature of the charge, the court will decline to reduce the bond at this time. However, I'm doing so without prejudice to the defendant filing a motion at a future date and time. Jose Chorna,
Yes, ma'am.
Sir, in your case, the court finds probable cause for petty theft with 2 prior convictions, and bond is stayed at $1,000. Court finds probable cause for resisting an officer without violence, bond is stayed at $500. As to the petty theft charge, you're ordered to have no contact with the victim and no return. You have several out on bond cases. As to case number 2022 CT 7878AO, bond is revoked, ROR is revoked.
Ma'am, these charges happened before, the charges I'm out on bond for. And every time, and this has happened the third time this has happened, I've gotten out of jail, and they're setting, every time I get out of jail, this happened 3 times in the last month or 2, and they said it, they give me another warrant on the day I get out of jail.
I don't understand what you're saying, but I will tell you what I think you're saying. You are thinking that because these charges happened before the new charge, that I should take no action on them, but sir, that's exactly why I should take action on them, because you have pending charges, and then you picked up a new charge.
No, all right.
Are you saying this happened first?
Yeah.
I believe he's trying to say, Your Honor, that the petty theft he's in arraignment for today happened prior to these other cases that he's out on bond for.
Well, you can't possibly be saying that, since he's saying that he keeps getting arrested over and over and over again on the same charge, the petty theft charge. And this is the first time I looked in the file when I saw this case, that I saw that he had gotten arrested on this charge. This just happened.
No, this petty theft charge is old, it happened before the.
But this is the first time you were ever arrested on this charge.
The first time I was arrested on this charge, but it happened before the charges I'm out on bond for.
So let me just say that I thought you were saying 2 different things. Number one, this case, I know the date of this case. I know when this case happened. I have no doubt in my mind about when this case happened. I simply thought that you were saying you were arrested over and over. You would bond out, and then you would get arrested again on the same case.
No, ma'am.
Okay,
Your Honor,
yes, Miss Fleming.
so I'm looking into it while you guys were talking about it.
Okay.
The petty theft 2 prior, Mr. Torna is here for today, I believe occurred July 4th.
Yes, ma'am.
The 7878 was previously revoked due to picking up the 22 mm 5604, which he's not here for today, or the 22 CF 9670, which is also one of his out on bonds. So one of his out on bonds previously revoked one of his other out on bonds, which I think is a lot of his confusion.
So he's about to get some more bonds, out on bonds revoked right now. So I am confident that we should revoke the out on bond cases as follows. 2022 CT 7878 AO. The court revokes the bond or the ROR and sets a bond. The court sets a bond of $1,000. The grand theft, case number 2022 CT 9670. The court revokes the bond and sets a bond of $10,000.
If the defense may add, no information.
There's one more case.
Sorry.
2022 CF 10763 AO. The bond is revoked. And the court sets a bond of $2,000. Now, Ms. Eugene?
Yes, I was gonna add that in regards to the grand theft and the other petty theft, no information has been filed in regards to those, the 9670 and the 10763. Would you take those into consideration when setting the bond amount?
Are you saying that the cases, the state has not filed an information, or the state has no information?
The state has not filed information yet in regards to those cases.
So, state there are two cases that Ms. Eugene says you have not filed an information on, which includes 2022 it looks like CF 1670 AO, and which is the other one, Ms. Eugene?
The 2022 CF 9670 AO.
Okay, that's the one I said. You said there was two.
9670 and 10763.
Okay, so as to 9670, has the state filed an information?
On 9670, no, it is not.
Okay, so on 9670, the court will take no action, and the court cancels the court's order to revoke the bond and order a $10,000 bond, no action instead. Now, as to which was the other case, there's three cases. It's starting to get confusing, and I don't remember which case you said, because I didn't write it down. Which one is it? The second case?
10763 has a private defense attorney, I believe,
10763 has what?
and information has not been filed.
So no information has been filed on number 10763, so the court will take no action on 10763. So the only case that an information has been filed on is 2022 CF 7878 AO,
Yes.
and I did order a bond on that one and revoke the ROR. And so hopefully that explains everything. And the court is also ordering, as to the case where I ordered a bond and revoked the ROR, no contact and no return. Yes, ma'am. No, ma'am. I set it at 1,000 and no contact, no return. The resisting, I set at 500. That's the second case, the second new case. Yes, 2 new cases and 3 old cases. Did we get that straight now?
Yes, thank you.
All right, thank you. Curtis Vance. Mr. Vance, in your case, you have 2 cases. The first case, possession of cocaine. Count 1, court finds probable cause, bond is set at $1,000. And count 2, possession of tetrahydrocannabinols, bond stays at $150. As to the second case of petty theft with 2 priors, the court finds probable cause, bond stays at $1,000. You're ordered to have no contact and no return. Thank you. Mary Ann Walker. As to your charge of aggravated assault with a deadly weapon, the court does find probable cause and bond will stay set at $3,500. You're ordered to have no contact with the victim, not to possess any firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you. Tracy Young.
Your Honor, I apologize. Can I speak to her for 1 minute, please? She has a question.
Yes, ma'am.
And Your Honor, state's also concerned. Miss Walker lives at 1224 Carter. I believe this happened at 1225 Carter.
Yes, ma'am.
So state's concerned regarding the proximity to the victim.
What do you suggest I do?
I'm not sure, Your Honor. State is concerned regarding the victim's safety, given the proximity. And it seemed unprovoked from the reading of the affidavit.
Yeah.
Your Honor, at this time, client would like to ask, are you willing to consider lowering her bond from $3,500 to something more reasonable for her?
What does she have priors?
Yes, Your Honor, she has 1 prior failure to appear, and then most of her other history is drugs, assaults, trespass, drugs.
Does she have any current cases pending?
Not
Or
that
is
I know of.
everything is prior?
I think everything is prior.
When was her most recent prior?
From PTR, it looks like 2011.
Yes, ma'am, I'll reduce the bond in her case. Ma'am, instead of $3,500, I'll reduce your bond to $1,500. Ma'am, the state has brought to my attention the proximity between your address and the victim's address. And I have already ordered you to surrender all weapons and firearms to law enforcement, and that includes knives. Do you understand that, ma'am? Every knife in your house needs to be surrendered to law enforcement within 24 hours of your release, because that was what was involved in this case, was a knife. You understand that?
Yes, but I didn't have any.
Also, ma'am, since you live so close to the victim,
No, the person who put me in jail, he don't even live over there.
okay, well, the address that is in the files, it appears to be that they're very close. So I'm going to order that you have no direct or indirect contact with the victim. You can go to your house. You just need to be very careful not to have any indirect contact with the victim. That means if you see the victim close to your house, that you turn around, you go the other way until you don't see the victim anymore. Do you understand? All right, thank you. Tracy Young.
Refuse, Your Honor.
Or you want to waive this one?
Yes, Your Honor, we can waive.
All right, the court finds probable cause on count 1, aggravated assault with a deadly weapon, and bond stays at $2,500. No contact, no return, surrender any weapons or firearms to law enforcement within 24 hours, and possess no weapons or firearms. No action on the out on bond matter. Rodney Dale Ziegler.
Yes, ma'am.
In your case, the court finds probable cause for possession of cocaine. Bond stays at $1,000, and possession of paraphernalia, bond stays at $100. Any other matters?
Nothing from the state.
Ms. Eugene, anything else?
Nothing further from the defense, Your Honor.
Madam Clerk, anything else we stand on the record for? Jill, staff, anything else? Court stands in recess. This is, or I should say, our first session. Judge Allen presiding, counsel for the state,
Taylor Fleming on behalf of the Office of the State Attorney.
defense.
Leslie Eugene on behalf of the Office of the Public Defender.
Thank you both. All right, let me call the Spanish interpreter.
Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Good morning, Laura. Have only one?
Yes, ma'am.
Okay. Jenny Javier Padilla Castaneda, 2022 CF 119518.
Your Honor, as the victims are not up yet, I don't know if there is a victim on this case, as it is a DV case.
Okay, thank you for informing. Deputies, do we know whether there are any victims that have not yet arrived into the hearing room? I'm sorry. I didn't hear you, Deputy, sorry.
I believe they're on their way, Your Honor.
Oh, they're being transported up now?
I believe so.
All right, we'll give it a minute. Laura, we'll call you right back, okay?
Yes, Your Honor.
Thanks. Okay, let me have him. All right, we'll just have the Castaneda case to stand by. Timbrel Battle. Battle. All right, we'll pass battle. Janice Negron. Ms. Negron? Yes. Ma'am, you were picked up for violation of your probation. Condition A, by failing to report by 2022, I apologize. And condition E, committing a new law violation to wit trespass on or about 9/22/22. Bond shall remain at no bond for this violation of probation. Thank you, ma'am. And, Madam Public Defender, just for the record, I am appointing the public defender on all cases unless otherwise noted.
Okay, no problem.
Elizabeth Grace Marrero? Ma'am, in your case, you were picked up for violating your probation. Condition A, failing to report, and condition D, by moving from your residence without the consent of the probation officer. And bond in your case shall also remain set at no bond. Thank you, ma'am.
Thank you, ma'am.
Your Honor, is that on both? I believe there's a warrant VOP as well as a on view.
I only got the warrant, sorry. I did not get the on view, just the warrant. Olga Estier Vadich-Shabir.
Your attorney reach out.
Morning, ma'am. In your case, you were picked up for violating your probation based upon several conditions. Conditions L, 3 counts of testing positive for cocaine on or about 9/15/22, on or about 8/8/22, and on or about 9/9/22. And also failure to complete a substance abuse eval and recommended treatment, for which bond shall remain set at $5,000, ma'am. Thank you. Did we get Timro Battle back yet from the restroom? Timro Battle? Still not ready? Okay. All right, the witnesses have come up, so we'll recall the Castaneda case, and I'll call the Spanish interpreter.
Good morning, Your Honor. This is Laura Royal, State Certified Interpreter.
Good morning. Recalling on the Castaneda case, case number 2022 CF 11951AO. And we do have a witness. Ma'am, do you speak English or do you need the Spanish interpreter?
Señora, ¿usted sabe hablar inglés o requiere los servicios de un intérprete en español?
Sí, español, por favor.
Spanish, please.
All right. We'll need to swear her in, Laura.
Muy bien, vamos a tener que hacer que usted preste juramento.
Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
¿Jura y promete que la declaración que rendirás es la verdad, toda la verdad, y nada más que la verdad, lo jura ante Dios? Yes.
All right.
Honor, I'm just going to direct her to move the mic a little bit to her face. She's short and I'm not hearing her very well. Señora, por favor, el micrófono, bájalo un poco hacia su rostro y su cara a la boca para que le oiga bien. Thank you, Your Honor.
Thank you. All right, ma'am, what is your name?
Señora, ¿su nombre cuál es?
María Orellana.
Maria Orellana.
All right, Ms. Oriana, either the state or defense may have questions to ask you. Please make sure you answer questions into the microphone.
Señora Orellana, posiblemente la Fiscalía o la Defensa tenga preguntas que hacerle. Le pido que cuando responda dirija su respuesta al micrófono.
Okay.
Okay.
Counsel.
Good morning, ma'am. Can you please state your relationship to Mr. Padilla Castaneda?
Buenos días, señora. Por favor, ¿podría usted indicar su relación Con respecto al señor Padilla Castañedo.
Sí, él es mi marido.
Yes, he's my husband.
Are you afraid of him?
¿Usted tiene miedo de él?
No,
No.
Has anything like this ever happened before?
¿Algo semejante o lo ocurrido alguna vez ha pasado antes?
no.
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Si algo semejante a lo ocurrido o algo mucho más grave de lo ocurrido fuera a ocurrir en el futuro, ¿usted se comunicaría con las autoridades?
Sí,
Yes.
And do you want to have contact with him while this case is pending?
Mientras que este caso esté abierto, ¿usted desea tener contacto con él?
sí.
Yes.
Your Honor, state has no further questions. However, I also believe the child is also one of the victims.
Su señoría, la fiscalía no tiene pregunta adicional que hacerle, pero posiblemente el menor fue una de las víctimas.
So the state has no objection to no hostile
No, ninguno.
with this
No,
victim.
none of them were.
However, would ask for no contact with the other.
I'm sorry, counsel, could you repeat that? You asking for no hostile, however, have no contact, and I didn't catch what
Yes.
came after that.
State would ask for a no hostile with Maria, given her testimony. However, would ask for a no contact with Jose, as he is the other listed victim.
La fiscalía está pidiendo que el inculpado no tenga ningún contacto hostil con María y ningún contacto en absoluto con José, el cual es un menor.
State, how old is Jose?
Fiscalía, ¿qué edad tiene José?
13, Your Honor.
15. Se va a cumplir.
15.
Okay, one at a time, please.
Solo una persona a la vez, por favor.
State.
Per the affidavit, it says 13, Your Honor.
Según el affidavit que tenemos, consta la edad de 13.
No, 14, va a cumplir 15 ahorita el 1 de diciembre.
No, he is 14 and he's going to turn 15 on the 1st of December.
Does he reside with you, ma'am?
Señora, ¿él reside con usted?
Sí, vive conmigo.
Yes, he lives with me.
At this time, the court orders as follows. I find probable cause for both count 1 and count 2.
En este momento dado, el fallo será el siguiente. Determino que existe suficiente indicios razonables de criminalidad con respecto al primero y el segundo cargo.
As to count 1, assault, aggravated assault, the court orders a bond of $1,000.
Con respecto al primer cargo, intimidación calificada, se ordena fianza de $1,000.
As to count 2, battery, the court orders a bond of $500.
Y con respecto al segundo cargo de agresión física, se dispone que la fianza será $500.
The court orders no hostile contact with the victim number 1, Maria Orellana.
Prohibido ningún tipo de contacto con respecto a la primera víctima, que sería María Orellana.
And the court orders no contact with victim number 2, Jose Orellana Padilla.
Y se prohíbe ningún contacto o trato en absoluto con la segunda víctima, que es José Orellana.
Court orders the defendant to possess no weapons and no firearms.
Prohibido la tenencia de arma de fuego o arma alguna.
And to surrender all weapons and firearms in his possession to law enforcement within 24 hours of release.
Y tendrá la obligación de entregar cualquier arma en su tenencia a las autoridades dentro de un plazo de 24 horas.
Given the fact that Jose Orellana Padilla resides with Maria Orellana, the court is ordering the defendant to not return to the location where this incident occurred.
Siendo que José Padilla reside con María Orellana, se hace constar en actas que el inculpado estará prohibido regresar al lugar de los hechos.
with the exception of a one-time visit in the presence of law enforcement to recover any personal belongings or effects.
Con la única excepción de poder regresar una vez escoltado por agente policial para recoger sus pertenencias.
Thank you.
Gracias. Your Honor, is the interpreter still needed or may she disconnect?
Madam Clerk. You may disconnect, Laura. Thank you.
Thank you.
Timbrel Battle. In your case, the court finds probable cause for, well, actually, you were picked up for violation of your probation, Condition A and Condition D, for which bond shall be set at no bond. Condition A is by failing to report to probation as of 9/16/22. And Condition D is by changing of residence without first procuring the consent of your probation officer. Thank you, sir. Giovanni Jose Cabrera.
Yes, ma'am. Good morning.
Good morning. Sir, the court is waiting for probable cause. Miss Fleming. Yes, ma'am, you may approach. Thank you, ma'am. Thank you, ma'am.
Since you're reading it.
All right, in your case, sir, the court does find probable cause for the offenses of count 1, burglary of a dwelling or a structure while armed, and bond remains set at no bond. Count 2, burglary of an occupied dwelling, bond stays at $5,000. Count 3, grand theft of a firearm, bond stays at $1,000. Count 4, grand theft of $750 or less than 5,000, greater than 750, and bond stays at 500. And the final count, grand theft of a motor vehicle, the court will set a bond of 100.
One second.
For clarification, count 2 is at 5,000 or 500?
Count 2 is 5,000. The court is ordering that you possess no weapons and no firearms as a condition of release, and that you surrender all weapons or firearms to law enforcement within 24 hours of release. Further, the court is ordering that you not return to the location where this burglary occurred, and that you have no contact with the victim.
Your Honor, can I get 1 minute to speak to him for a second?
Yes, ma'am.
Thank you.
For the hearing, for the next case, do I use this box to turn them on or this one? This one? Okay. Okay. Courtroom video space?
Not as of now, but I'll have your attorney reach out to you. problem.
Ms. Eugene, I'm going to move to the next case now.
Yes, Your Honor.
Jesse James Figueroa. This is a reset from yesterday, and I have been informed that Mr. Adam Reese is appearing virtually. I hit it again. Courtroom video space. Is it courtroom video space or BRC? Okay. It's busy because I'm calling it so many times. I'm gonna try the BRC, see that one. 1, 2, 3.
Yes. That one actually takes me the longest to do.
Okay, it does have one here that says courtroom video space, and then when you go down, it does say, or, I mean, at least. Yeah, that's the one, courtroom video space. It defaults back. That's not gonna work. No, that's not gonna work. It's definitely. Space interpreter, courtroom video space. I'll try this one. Okay. BRC 1? Let's just call the attorney. Yes, 407. Transfer it up there. Mr. Reese, good morning. This is Judge Allen. All right, I'm moving too fast. Mr. Reese, good morning. This is Judge Allen. Okay. Will you tell me when to say something? Okay. Okay, Mr. Reese, good morning. This is Judge Allen.
Good morning, Judge Allen. How are you today?
I'm doing well, and we're going to see if we can turn the volume up just a little bit. I can hear you, but you're coming in a little faintly.
Okie dokie. I'll speak louder as well.
Okay, I've turned you up a little bit, and we do have Mr. Jesse James Figueroa in the courtroom at this time. He informed me on yesterday that he said he had a private attorney, and it turns out to be you.
Yes, ma'am. And I believe that notices of appearance have been filed in both cases. I didn't see them docketed yet, but my legal assistant advised that they were forwarded and e-filed. The misdemeanor new case, I know the court has set bond with various conditions, and there's no objection to that. I'm hoping that the felony case that Mr. Figueroa is being held on, that the bond could either be set or reinstated. I noticed that the paperwork indicates revoked. Mr. Figueroa has a very supportive family. I would ask the court that if the bond in that case is not revoked or reinstated or reset, that as a condition of the bond, that Mr. Figueroa would agree to participate in a substance abuse evaluation and begin treatment as recommended. As I mentioned a minute ago, Mr. Figueroa's family is very supportive. This immediate contact or this immediate conduct over the last few days is troubling to the family. And I spoke with Jesse Figueroa, and he is very inclined to begin providing mitigation type evidence and pursuing what is necessary so that this isolated conduct does not become a recurrent behavior.
The court is amenable if, in fact, he is willing to participate in a substance abuse evaluation and treatment as a condition of the court taking no action on revocation, but adding that condition to his release status, then I am amenable to that. But however, let me have the state address it. And just for clarification, you are suggesting to add it as a condition of his release, correct?
That's correct.
Ms. Fleming.
Your Honor, state would object. They are both violent offenses picked up within 2.5 weeks of each other. So state is concerned regarding the victims in both cases and the rest of Orange County, given they are so close in time. They are both violent in nature. I believe there's not a victim on either case here either. And he does have an attorney working for him. So state would ask that it remain at none, so the bond hearing can be set downtown, so all the victims can be present and be heard, given that they are so close in time and both violent offenses.
So the defendant is entitled to a bond on the battery case, which the court set that bond on yesterday.
Yes, Your Honor.
And I don't recall whether a victim was here or not, but he's entitled to a bond.
He is, Your Honor. You said it at 500. The state has no objection to that.
Okay.
However, him being out on bond and picking up a new law offense, he is not entitled to a bond on that case if Your Honor does not decide to set one and decides to revoke it.
Well, the court is, I'm hearing some additional information today that was not provided to the court on yesterday. Had Mr. Reese informed me of the defendant's willingness to immediately undergo a substance abuse evaluation and comply with treatment, the court would have taken that into consideration. I would not have revoked the bond. Consequently, the court is going to amend the court's order revoking the bond and take no action on the revocation of the bond.
Your Honor, just for the record, I don't believe there's any substance abuse in either of the affidavits. And when he spoke to PTR, he didn't report anything.
He's voluntarily agreeing to do it, which is promising to the court. So based on his volunteering to comply with it, I'm ordering as follows. As a condition of bond, along with the previously ordered conditions, the defendant is required to undergo a substance abuse evaluation within 30 days of release, provide a copy of the evaluation to the court file, and comply with treatment. Further, the defendant is ordered to consume no alcohol and consume no illegal narcotics as a condition of bond. The defendant is ordered to submit to weekly drug testing and/or urinalysis through the pretrial release program. Also, a copy of the substance abuse eval must be provided to the state. Mr. Reese, that's the court's order.
Thank you, Judge. No objection to any of that.
All right. Anything further from either the state or Mr. Reese as to Mr. Jesse James Figueroa?
Nothing from the state.
Nothing from defense, Your Honor. Thanks for having your clerk reach out to me. I appreciate it.
All right, thank you, Mr. Reese. The court is also ordering that the public defender is, I'm canceling the order from yesterday, appointing the public defender and vacating that order. I'm vacating the $50 public defender fee.
Thank you, Judge. Have a wonderful weekend.
Yes, thank you, sir.
You're welcome.
Why am I so hot all of a sudden? What happened? Did I just get nervous? Here, see if it works. It works. Autumn Grove. All right, reset. Wait a minute, I did find probable cause on this case.
And she qualifies for pretrial.
Ms. Eugene, Autumn Grove.
We can waive, Your Honor.
All right, the court will order the defendant be released in the pretrial release program with the conditions of no contact with the victim and no return. Jordan Hinkle. Sir, in your case, the court does find probable cause for trespass on property after a warning.
Yes, Your Honor. I do apologize.
Yes, ma'am.
This is supposed to be a no contest plea. He was supposed to plea yesterday. It was reset from yesterday for him to plea. Can I just have 1 minute so he can sign the plea form, Your Honor?
Yes, ma'am.
Thank you.
What is that noise?
The crunching noise?
Did I hang up on Mr. Reese? Oh, I'll tell Juanita to tell him to hang up. I just told Juanita to tell him. I told her by text, just in case anybody thought I had the ability to talk to her without actually seeing her. I texted her that I can't talk to her without the phone. You know, it's like, that's impossible. All right, just clarify for the curious. All right, are we ready with Mr. Hinkle?
Not yet. I apologize, Your Honor. 30 more seconds, please.
Yes, ma'am.
Can I just get the case number, Your Honor? I apologize.
2022 MM 6947 AO.
Client will be entering a no contest plea with the agreed upon disposition of adjudication of guilt, credit for time served, and no return to the Circle K located at 9988 South Orange Avenue.
How much time served does Mr. Hinkle have?
3 days.
3 days. All right, Mr. Hinkle, is this your signature here at the bottom of this plea form, sir?
Yes, ma'am.
I need you to speak up, sir.
Yes, ma'am.
Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication at this time?
No, ma'am.
Do you understand that a conviction on your case will subject you to being deported if you are not a U.S. citizen?
Yes, ma'am.
All right, sir. There is a sufficient factual basis in your case, and you are alert, you're intelligent. At this time, you're adjudicated guilty, sentenced to serve 3 days in the Orange County Jail with credit for 3 days' time served, and I am further ordering that you not return to the Circle K at 9988 South Orange Avenue. I assume that's Orlando? Orlando, Florida. Further, you must pay all mandatory court costs associated with the charge within 180 days of your release, and I am ordering your release as to this charge. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
And Your Honor, he does have an out on bond. State's requesting no action given him resolving this case.
Yes, ma'am. The court takes no action on the out on bond case. Thank you. Beatrice Matos? Good- Hi. At this time, ma'am, the court is informing you of your violation of probation or violation of conditions of pretrial release, I apologize, by violating your no contact order, and the bond will stay set at $5,000.
Yes, Your Honor, I'm sorry. I don't understand why I wasn't explained. I went to court. I don't know how I violated the terms if I haven't spoken or seen the victim. I haven't been anywhere around there, and I don't know how did I violate. I just got out of jail. I've been trying to look forward doing the right thing, and I don't understand how did I violate.
State, do you have any additional details about the violation of the no contact order?
No, Your Honor, not other than what you've already stated on record.
Yeah, so I don't know how did I violate it. I just got out and I've been trying to look for work. I don't understand.
Your Honor, PTR is who files the violation. I don't know if PTR has any other additional information.
PTR make reference to an incident report from Orange County Sheriff's. I need that incident report. I'll reset the case for 24 hours. The state is ordered to locate the Orange County Sheriff's Office incident report that was referenced in the violation of pretrial release order. And ma'am, I'll give the state 24 hours to do that. And I will readdress we will readdress your case in the morning.
Okay, thank you, Your Honor.
All right, thank you, ma'am. Jonathan Fernandez Del Cid.
Your Honor, he qualifies for pretrial.
Thank you, ma'am. Sir, in your case, the court finds probable cause for battery, domestic violence, and I am ordering a bond. I am not ordering a bond. I am ordering you to be released on the pretrial release program. The conditions are as follows. You're required to have no contact with the victim. You're also required to surrender any weapons or firearms to law enforcement within 24 hours of release and possess no weapons or firearms as a condition of release. No return with the exception of a one-time visit in the presence of law enforcement to recover personal belongings and effects. Due to your income, the public defender is not appointed in this case. You also are ordered to comply with all other conditions of pretrial release. Thank you, sir. Thank you. That's correct. Kevin Mendez.
And he qualifies for pretrial as well, Your Honor.
All right, sir, in your case, the court finds probable cause for tampering with a witness to hinder communication. State any objection to pretrial release on this case?
No, Your Honor. However,
right.
DCF was also called.
Okay, in this case, I will order you to be released in a pretrial release program. You're ordered to have no contact with the victim, no contact with the minor children, comply with any DCF order, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. And any other conditions, state, that you're recommending in this case?
No, Your Honor. I believe they already lived in separate residences.
Thank you. Sylvia Mincy. Ms. Mincy, in your case, ma'am, the court finds probable cause for battery, domestic violence. You also have a violation of probation on view for which bond will stay set at no bond. As to the battery, the court orders a $500 bond.
Your Honor, there is a witness.
Oh, I'm sorry, I had not noticed. Sir, would you raise your right hand to be sworn in?
Yes, ma'am.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
All right, thank you. What's your name?
Arthur Holly.
Okay, I'm gonna need you to speak into the microphone, and I need you to project, okay?
Yes, ma'am.
Go ahead, what's your name?
Arthur Holly.
Holly?
Yes, ma'am. Arthur Holly.
All right, sir, either the state or defense may have questions of you. Please project when you speak into the microphone. Otherwise, we're going to have to ask you to repeat yourself every single time.
Yes, ma'am.
Good morning, Mr. Hawley. Can you please state your relationship to Miss Mincy?
Her boyfriend.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes, ma'am.
Do you want to have contact with her while this case is pending?
Yes, ma'am.
That's all I have, Your Honor.
Anything, Ms. Eugene?
Nothing further, Your Honor.
All right, the court orders a bond of $500. Further, the court orders no contact, no hostile contact with the victim, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. That's as to the battery. As to the VOP, bond will remain at no bond. James Thompson. Good morning, sir. In your case, the court does find probable cause for aggravated assault. And I set a bond of $1,000. In order, no contact with the victim, no return, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. And thank you.
Yes, ma'am.
Brian Conalon.
Your Honor, he qualifies for pretrial as well.
Okay, thank you. Mr. Connell, in your case, I do find probable cause for the charge of battery, domestic violence. You qualify for pretrial release. I am ordering that you be released on the pretrial release program. You are required to comply with all of the terms and conditions of pretrial release. Further, you're ordered to have no contact with the victim, no return with the exception of a one-time visit in the presence of law enforcement to recover personal belongings. Further, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. And thank you, sir.
Well, thank you.
Your Honor,
Yes, ma'am.
on his warrant, it requested that he has a RUA. Did you want him to have a RUA?
Let me see the warrant again. One moment, sir, before you exit. The court is further ordering that you possess and consume no alcohol or drugs and submit to random urinalysis while participating in the pretrial release program.
Thank you.
Thank you, sir. Marcus Atkins. Mr. Atkins, in your case, the court does find probable cause for battery, domestic violence, and I am ordering a bond of $500. Further, I am ordering you to have no contact with the victim, possess no weapons, possess no firearms, surrender all weapons or firearms to law enforcement within 24 hours of release, ordering you not to return, with the exception of a one-time visit in the presence of law enforcement to recover any personal belongings or effects. Thank you. James Johnson. Sir.
He qualifies for pretrial as well, Your Honor.
In your case, the court does find probable cause for both count 1 and count 2. Count 1, battery, domestic violence. Count 2, leaving the scene of a crash with property damage. You qualify for the pretrial release program, therefore I am ordering you to be released on that program. I am not appointing the public defender as you do not qualify based on income. Sir, you must comply with all of the terms of the pretrial release program. Additionally, you are ordered to have no contact with the victim, no return with the exception of a one-time visit to recover any personal belongings or effects, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you, sir. Jamie Lynn.
And she qualifies for pretrial as well, Your Honor.
Right. Jamie Lynn, in your case, the court does find probable cause for battery, touching, or striking, and I am ordering that you be released in the pretrial release program. Further, you are ordered to comply with all of the terms of the program. You do not qualify for the public defender based on income, so I am not appointing the public defender. Additionally, you're ordered to have no contact with the victim, no return with the exception of a one-time visit to recover personal effects in the presence of law enforcement, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Rachel Smith Altum.
And she qualifies for pretrial as well, Your Honor.
All right, is there, are you a witness for Rachel Smith?
Yes, ma'am.
Ms. Smith is not present due to some mental health concerns. I am appointing the public defender in her case, and it will be up to the public defender if the public defender wants me to have the hearing right now or to reset the case.
We can have the hearing right now, Your Honor, it's fine.
All right, we'll move forward. Sir, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, swear or affirm, sir?
Yes, ma'am.
All right, and sir, what is your name?
My name is Alex Castro.
Okay, Mr. Castro, either the defense or the state may have questions of you. Please answer the questions.
Okay.
Good morning, Mr. Castro. Can you please state your relationship to Ms. Smith?
I'm her boyfriend?
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Absolutely.
And do you want to have contact with her while this case is pending?
Absolutely.
That's all
We
I have,
need her
Your Honor.
back.
All right, and Ms. Keys, you said she qualifies for pretrial release?
Yes, Your Honor.
So the court does find probable cause, and I order the defendant to be released in a pretrial release program. The defendant is ordered to comply with all of the terms of pretrial release. Further, the defendant is ordered to have no hostile contact with the victim and possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, Mr. Castro.
Can I just ask one quick question?
You
Because
may.
with the mental health thing, is there anything special I have to do with that? Is she going to be?
No, there's nothing special you have to do. You just have to love and care for her.
Okay.
That's not special, that's normal, right?
No, I know. It was just the first time I heard anything mental health get brought up.
Okay, sometimes people get stressed out and they just need an evaluation. We really don't know the details of that. She's being released in a pretrial release program, so you can contact pretrial release to find out the exact time of her release.
Understood. Thank you so much.
All right, thank you. James West. Mr. West, in your case, the court does find probable cause for battery, domestic violence.
Your Honor, he qualifies for pretrial as well.
You qualify for pretrial release, and so I'm ordering you to be released on the pretrial release program. Further, I'm ordering you to comply with all of the terms of pretrial release, and I'm ordering you to have no contact with the victim.
Your Honor, this is
That's
the one
the
that I was
telephone.
told.
Oh, this is the one with the telephone, so we're gonna call. We have a witness, and we need to call the witness, okay? Do, state, the witness is being called and is excused from being here in person due to the witness having been released from the hospital this morning.
Okay.
You're gonna put her on the overhead? Okay. Ms. Hoffman, this is Judge Allen. Can you hear me?
Yes, ma'am.
All right. We're going to conduct the hearing. We do understand that you were released from the hospital, so I excused you from being here in person. Either the state or the defense will have questions for you, and we just need you to respond accordingly, okay?
Yes, ma'am.
State.
Your Honor, do you want to swear her in or?
Oh, yes, I can swear in. Sorry. Ms. Hoffman, do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And just to confirm, your date of birth, ma'am, can you tell me?
02-16-1963.
All right, thank you very much. State, you may inquire.
Good morning, ma'am. Can you please state your relationship to Mr. West?
He's my boyfriend. We've been together off and on since 1998.
Are you afraid of him?
I am now.
Has anything ever happened like this in the past?
Not that I can recall.
If anything like this or anything more severe ever occurs in the future, would you feel comfortable calling 911?
Yes.
And do you want to have contact with Mr. West while this case is pending?
I love him.
That's all I have, Your Honor.
Your Honor, I'll be asking for a no hostile contact and that they maintain the same residence.
Our state would object, given the victim's testimony.
Court's going to order no contact. All right, I do find probable cause for the charge of battery domestic violence. I am going to order you to be released on the pretrial release program. I'm ordering you to have no contact with the victim, maintain a separate residence. You can return one time in the presence of law enforcement to recover personal effects. You must possess no weapons and possess no firearms, and surrender all weapons and firearms in your possession to law enforcement within 24 hours of release. Ms. Hoffman, we just hope that you get better, and we do understand emotions and feelings, and so we hope for the best for you, okay?
Yes, ma'am.
Thank you. You can disconnect now, Ms. Hoffman.
Thank you.
Ms. Hoffman, you can disconnect. It's not gonna happen every time we do a phone conference. It's even worse this time. If she's saying she hung up, how can she tell you she didn't hang up? If she hung up, she wouldn't be able to tell you she hung up. Okay, can you hang up again? Can you just keep hanging up? Hang up multiple times. All right, we gotta figure that out. That's a law. Gavin Flamett.
Yes, ma'am.
Sir, the court, you were picked up on an out-of-county warrant from St. Lucie. Bond stays at $10,000 in your case. Thank you. Marco Portalatin. Sir, in your case, you were picked up on an out-of-county warrant from Seminole for 6 counts of grand theft and 6 counts of criminal mischief. And there is a $3,000 bond on each of the 12 counts, $3,000 each. You understand?
Could I bond out today if I wanted to?
Yes, sir, you are able to bond out. You have the ability to post a bond if you wish to do
You're
so.
not gonna hold me or nothing?
No, not if you are able to bond out. The bond can be posted, sir.
All right.
All right, thank you. Christian Stillwell. Sir, you were picked up on an out-of-county warrant from Seminole County, 12 counts, 6 counts each of grand theft and 6 counts of criminal mischief. Bond is $3,000 per count. Each count is $3,000. Do you understand? All right, thank you, sir.
Bond out today, or
Yes, sir, you are able to bond out.
I don't got no holds or nothing?
No, there's no hold on this case, sir. There's no hold. You may bond out if you are able to do so financially. All right, thank you. Thank you, sir. Daniel Albert Diaz. Sir, you were picked up for violating your probation, a special condition of failing to complete 100 hours of community service by August 15th, 2022, and bond is stayed at $1,500. Thank you, sir. Corey Anthony Edwards. Mr. Edwards, you were picked up for violation of your probation, condition N, for urine that was positive for marijuana metabolite on or about September 1st, 2022. Bond will stay at no bond. There were actually 2 positives. They're both dated the same date. So thank you, sir. Efren Ruiz, in your case, you were picked up for violation of your probation for condition D and several other violations. The condition D is a new law violation of possession of fentanyl and possession of paraphernalia on or about August 9th, 2022, and it's from Polk County. The additional violations are the new law violation, condition E, the new law violation, condition K, associating with persons engaged in criminal activity, and condition N, using intoxicants to excess or possession of any drugs or narcotics. Bond will stay at no bond. Thank you. David Vault. Would you like for me to go ahead on and, well, I have appointed the public defender. Would you like for me to waive his presence?
Yes, Your Honor, we can waive.
All right, the court did, the defendant was picked up for violation of probation, 2 cases, bond stays at no bond on both cases. Clifford Grant Sutton, good morning, sir. In your case, you were picked up for violating your probation, condition number 4, committing an offense of trespass on property after a warning on or about October 4th, 2022, and condition 7, failing to comply with instructions of the court on or about September 23rd, 2022, when you failed to report to probation. Bond will stay at no bond. Thank you, sir. Jamar Jarvis, sir, in your case, you were picked up for violating your probation, 2 counts. Condition 4, on or about October 9th, 2022, committing a violation of a domestic violence injunction. And the second count, a similar charge, on or about October 9th, 2022, commission of a violation of a domestic violence injunction, and bond stays at no bond. Thank you, sir.
I apologize, Your Honor, you said no bond?
No bond, yes, ma'am. Michael, I'm sorry, wait, how?
3 of them, you said no
You
bond.
said there are 3 cases?
Yes.
3 cases. Are we talking about Jamar Jarvis?
Sorry.
Because I only have 1 case for
This one,
Jamar.
Your Honor, sorry.
Oh, okay. Now, I do have 3 cases as to Michael Thomas.
Yes, Your Honor.
Mr. Thomas, now you were picked up for violation of your probation. You have 3 cases. The conditions on violation are the same on all 3 cases. Condition 4, a new law violation of battery domestic violence on or about October 9th, 2022. Special condition, not maintaining no hostile or violent contact with the victim, LaToya Gay, on or about October 9th, 2022. Special condition, failing to enroll in the BIP Batterers Intervention Program within 20 days from release. And special condition, failing to undergo a drug and alcohol eval within 20 days from release. Bond will remain at no bond on all 3 violations. Thank you, sir. Do we have any release motions? Okay. All right, motions for release. Madam Prosecutor, do you want to announce these?
Yes, Your Honor. Sometimes we have them out of order.
Oh, that's right, you don't have them in order. Okay, Daniel Hart,
22 CF 10647, granted, notice of non-filing.
all right, that is granted. Today is the 14th, Madam Clerk? Okay, let's go ahead and date these. You know, Madam Clerk, it's okay if you all date these for me. Okay, that's why it takes so long for me sometimes. So the next case is Marco Jamal Graham.
22 CF 10042, granted, notice of non-filing.
And that is granted, yes, ma'am. Nicholas Allen Middleton.
22 CF 10607, granted, notice of non-filing.
Granted. Antoine Demetrius Wilson.
22 CF 10609, granted, notice of non-filing.
All right, that will be granted. Robert Earl Pedraza.
22 CF 10155, granted, notice of non-filing.
Thank you, ma'am, that is granted. Earl Lopez Rubio.
Denied, it's premature, 33rd day is Monday.
All right, denied as premature. Anthony Lindo Paul, or Paul Anthony Lindo, that might be the correct order.
22 CF 7122, granted, it was no build.
All right, that motion's granted. And Lloyd Courtney Roberts.
22 CF 10634, granted, notice of non-filing.
That is granted. Peyton Lee Baker.
22 CF 10680, denied, and information was filed.
Yes, ma'am, I'll deny that one. We have a couple of add-ons, I believe.
Yes, Your Honor.
Let's see here. Marco Trevon Key.
22 CF 10913, denied, and information was filed.
That is denied. Yes, ma'am. And Robert Sweet.
22 CF 10536, denied, and information was filed.
That is denied as well. I think that concludes all of the add-ons and the release motions. Anything further for the first session, Madam Clerk? All right, court will be in recess.